Good morning, ladies and gentlemen. I'd like to welcome you to County Court Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court Law Number 2. This morning, you've been asked to come here for what we call an arraignment. And what the arraignment is just an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. We handle criminal cases. The type of criminal case that you have is a misdemeanor criminal case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are normally referred to as your more serious type of offenses, whereas your misdemeanors are referred to as your petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can get if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. Now, if a person is convicted of a third-degree felony, the range of punishment is minimum 2 years in the state penitentiary and up to 10 years and a fine that does not exceed $10,000. Now, if a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of the highest felony, which is capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about those punishments because, as I mentioned to you earlier, you have a misdemeanor case. Misdemeanors are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, the Class C misdemeanors are cases that start in the city court or the JP court. They come to this court after the person is convicted in the city court or the JP court, and then they appeal their case. They get a whole new trial. But the punishment range is still the same. And the punishment range is fine only. And the fine cannot be above or exceed $500. An example of a Class C misdemeanor would be speeding, not having your seatbelt on, having an expired sticker. Those are just some examples of Class C misdemeanor. Now, the next highest misdemeanor is a Class B misdemeanor. Now, with the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days, which is 6 months, in the county jail, or the person will be given a fine that does not exceed $2,000, or they could be given both such jail time and the fine. Now, the highest misdemeanor is a Class A misdemeanor. If a person is convicted of a Class A misdemeanor, the minimum is 0 days to a maximum of 365 days in the county jail, which is a year, or they could be given a fine that does not exceed $4,000, or they could be given both such jail time and a fine. Now, you may be eligible for probation. There are 2 types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation is normally referred to as deferred probation. What that simply means is if you get on that type of probation, you don't have a conviction on your record. And if you successfully complete that probation, the case will be dismissed and you may qualify for what is called a non-disclosure. What a non-disclosure is, your record is sealed to the general public. That is, the general public cannot see your record because it's sealed to them. Now, the operative word that I used was general public. And that simply means that there are certain government agencies listed in the Texas Code of Criminal Procedure that can have access to the record. For example, the police department. Okay, but most of the public is general public, so most of the public cannot have access to it. So if you have a, let's say you were at Exxon Mobil, you applied your job at Exxon Mobil, and you had a non-disclosure. They do a criminal background check. Guess what? They won't see that case because your record is sealed to the general public. They're part of the general public. Now, the next type of probation is called adjudicated probation. The first one I talked about was unadjudicated probation, and now we have adjudicated probation. With adjudicated probation, it does result in a conviction on your record. However, there's something that is called judicial clemency, where a judge can set your conviction aside and you will no longer have a conviction. And so you will no longer have a conviction on your record. However, if you get a subsequent conviction, that is, you get another conviction later on, then the case that you received judicial clemency on can be resurrected, it can be brought back up, and it can be used against you. And if you try to get a license with Child Protective Services, which is CPS, they can deny, give you a license. If you have a license, they can revoke or suspend your license. Now, you can, as a defendant in a criminal case, as a person who's been charged with an offense, you can enter one of three types of pleas. You can enter a plea of not guilty. If you enter a plea of not guilty, you tell the court that you did not commit the offense that you've been charged with, or you could enter a plea of guilty. If you enter a plea of guilty, you tell the court that you committed the offense that you've been charged with, or you could enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be fighting or you will not be contesting the charges. Now, everyone that's here for a case, you should have a clipboard. Who does not have a clipboard? Everyone have a clipboard, okay. And the reason why I'm asking you to make, well, the reason why I'm checking to make sure that you have a clipboard is because I'm getting ready to go over that information that's on that clipboard. Now, the first page is a document that looks like this. It should say judge's explanation of rights to defendants without attorney. Now, everybody's gonna sign and initial this document. And I will constantly refer back to this document. Okay? Now, this document states that as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you can't afford to hire an attorney and you would like to have an attorney to represent you, you may request or ask that an attorney be appointed to represent you. And number three, you may waive your right to have an attorney, or give up the right to have an attorney and represent yourself. All right. Now, the first sentence under number three states that if you want an attorney and if you can afford to hire an attorney, your case will be reset. Reset means that you'll be given another court date. Why? To give you time to hire your attorney. Okay? The next sentence below that states that if you want an attorney, but you can't afford to hire an attorney, you may request that an attorney be appointed to represent you by the court, but you must first fill out a financial questionnaire so that the proper person can determine whether or not you qualify for a court-appointed attorney. Now, the financial questionnaire is a document that is on the clipboard. It's a 3-page document. It is titled Jefferson County Affidavit of Interest. Now, you will only fill out this document if you are applying for a court-appointed attorney. So, for example, if you're not applying for a court-appointed attorney, if you want to hire your own attorney, if you want to represent yourself, you don't need to sign it. This is only if you would like to apply for a court-appointed attorney. So those of you who would like to apply for a court-appointed attorney, you have to fill out this entire first page. And then you go to the second page. And on the second page, you're gonna fill out the top portion that is titled Defendant's Oath. Defendant's Oath. And then you'll fill out the middle portion that is titled Unsworn Declaration by Defendant, and then you'll stop. Okay? Now, going back to this first document, if you would like to waive or give up the right to have an attorney, if you would like to represent yourself, where you will be your own attorney, then you'll have an opportunity to talk to the prosecutors that's in the court. Prosecutors or assistant criminal district attorneys. They work for Jefferson County District Attorney's Office. You'll have an opportunity to talk to them to see if you can work out a settlement case. Why would you have an opportunity to talk to them? Because just like an attorney would have an opportunity to talk to them to settle your case, you are your own attorney. If you represent yourself, you are your own attorney, so you can talk to them to see if you can work out a settlement in the case. All right, but this third one sentence paragraph states that you may not speak to the prosecutors unless you first sign a waiver of your right to be represented by an attorney. In essence, the waiver is a document that is another one-page document that's on the clipboard. Now, this is only for people who will be representing themselves. If you are hiring your own attorney, or if you're asking for a court-appointed attorney, you don't have to sign this. All right? This is only for people who will be representing themselves. And this document basically states that, one, you know you have a right to have an attorney, and if you can't afford one will be appointed to represent you. However, you are waiving or giving up the right to have an attorney to represent you, you would like to represent yourself. That's what this waiver is saying. Now, this is only for people who will be representing themselves. They would have to read and sign this document, and then you'll have an opportunity to talk to the prosecutor in your case. Now, also for individuals who will be representing themselves, there's a paragraph, it's in block form. It states, be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, this last one sentence paragraph is also for people who will be representing themselves. It states that if you're representing yourself, you may change your mind at any time and request that an attorney be appointed to represent you. So, for example, let's say you're representing yourself, and let's say you have in mind that you would like to get probation, okay? And you talk to the prosecutor. Prosecutor say, well, I'm not offering you probation. I'm offering you a fine. I'm offering you jail time or whatever. And so you say, well, I don't want that. So you can say, well, Judge, I changed my mind. I don't want to represent myself. I want to apply for a court-appointed attorney. You can do that. Okay. Now, at the bottom of this document, in bold letters, it states defendant's choice. Mark initials next to only one choice. Now, everybody's going to make a choice. And there are 5 lines to the left at the bottom. If your choice is to hire your own attorney, then you'll place your initials on the first line to the left. Okay? And then you'll sign your name at the bottom of the document where it says defendant, and you will date the date, today's date, March 31st of 2026. And then you'll stop. And this will be the only form that you have to sign. You don't have to worry about nothing else. Now, if your choice, if you have already hired an attorney to represent you, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. Then you assign your name at the bottom of this document where it says defendant, dated today's date, and then you'll stop. This is the only form that you would have to sign. If you would like to apply for a court-appointed attorney, then you'll place your initials on the third line to the left at the bottom. And you'll sign and date it, and then you will fill out this document that is titled Jefferson County Affidavit of Indigence. You will fill out the entire first page, and you will fill out the top portion that says defendant's oath, and the middle portion that's titled unsworn declaration by defendant, and then you'll stop. Now, if you would like to, if you've already been appointed a court-appointed attorney, then you'll place your initials on the fourth line to the left, and the name of the attorney on the line to the right. You will sign this document where it says defendant, that is today's date, and then you'll stop. Now, if you would like to represent yourself, that is, waive your right to an attorney to represent yourself, you'll place your initials on the fifth line to the left, and then you will sign at the bottom and date it, today's date, and then you'll fill out this form that is titled waiver of counsel for purposes of entering guilty plea or proceeding the trial. You read and sign this document, then you stop. Okay. Do we have any questions? We have, yes. You represent yourself. So if you represent yourself, you'll place your initials on the fifth line to the left, sign and date it, and then you fill out this form that is titled waiver of counsel for purposes of the entering guilty plea or proceeding the trial. And then at some point, you'll talk to the prosecutors. Any other question? Yes.
After you talk to the prosecutor and you're not happy with the result, you can go back to.
You can change your mind. Yeah, that's what the last sentence says. You may change your mind at any time and request that an attorney be appointed to represent. Okay. All right. Anybody else? Now we're gonna give you time to fill out that paperwork. You don't have to don't fill it out right now because there's some other information that I have to give to you. Now, let me do this here. The next thing I want to talk about is your right to have a trial. That area over there where you see those 12 chairs, we call that the jury box. Now, this is a misdemeanor court. This is a county court at law. So in county court at law, a jury is a jury of 6 in the state of Texas. In district court, it's a jury of 12. Okay, we have 12 chairs here. I just need you to understand that. So 12 individuals of 12 citizens from Jefferson County will be selected to serve as jurors in your case. And what they will do is they will listen to all the evidence that's presented by the state, evidence by the defense, listen to the arguments of the state, listen to the arguments of the defense, and then they will go back into the jury room, deliberate, and they can find you either not guilty or guilty. Now you can waive your right to have a trial by jury. Waiving means you can give up your right to have a trial by jury. If you waive or give up the right to have a trial by jury, that means that you will not be having a jury trial. You still can have a trial, but you will have what is called a bench trial. And what a bench trial is a trial by judge only, but the judge will be the judge and the jury in the case. The reason why you call it a bench trial is because the judge sits on the bench. So they just call it a bench trial. Okay, so the judge will listen to the evidence that's presented by the state, evidence presented by the defense, arguments of the state, arguments of the defense. Judge will apply the facts of the law and decide whether to find you not guilty or guilty. Now, if you decide that you didn't want a trial and you want to enter a plea of guilty or no contest, or see if you can work out a plea bargain, then there are 2 types of plea bargains. One type is called an agreed plea bargain. That simply means that you and the state have reached an agreement. The other type of plea bargain is called an unagreed plea bargain, which means you and the state have not reached an agreement. I you still want to plead. I'll explain the difference. But the agreed plea bargain, you and the state have reached an agreement, and then it goes before the judge. The judge can do 1 of 2 things. The judge can accept or reject the plea bargain agreement. If the judge rejects your plea bargain agreement, then the law states that you have a right to withdraw or take back your plea. In essence, you can say, well, judge, well, first of all, let's say You and the state came to an agreement, you want probation, they offer probation, it comes before the judge. The judge said, I'm not gonna follow that. When you say, well, judge, since you're not following the plea bargain, I'm not pleading guilty or no contest. I take back my plea. You have a right to do that. They call that you have a right to withdraw the plea. If the judge does not follow the plea bargain agreement. Now, if the judge follows the plea bargain agreement, and if within 30 days you say to yourself, you know what? I think I was wrongfully convicted. Or the court committed an error convicting me. When you have a right, then you have to go before the judge so that he or she can give you permission to appeal your case. If you get permission to appeal your case, then your case is going to leave this court and it's going to go right upstairs to the Ninth Court of Appeals. The Ninth Court of Appeals, there are 4 justices up there that will review your case. They can do one or two things. They can grant or deny your appeal. If they grant your appeal, they can simply find you not guilty. Or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, guess what? You can appeal it to a higher court than the Ninth Court of Appeals. You can appeal it to the highest criminal court in the state of Texas, which is the Texas Court of Criminal Appeals, located in Austin, Texas. You have to file what is called a pro se petition for discretionary review. What that simply means is this. Pro se means you represent yourself. You're petitioning, or which means you are asking the Texas Court of Criminal Appeals to review your case to see whether or not the Ninth Court of Appeals should have granted your appeal, or whether this court committed an error, or whether this court wrongfully convicted you. Texas Court of Criminal Appeals could do one of two things. They could grant or deny your petition. If they grant your petition, they can simply find you not guilty, case over. Or they can send the case back to the Ninth Court of Appeals with orders, or they can send it back down to this court with orders. Now, if they deny your appeal at that point, your conviction will stand. Now, with the unagreed plea bargain, as I mentioned to you, you had an agreed plea bargain. Now you have an unagreed plea bargain, which means that you and the state could not come to an agreement on what your punishment should be. Then it goes to before the judge. You want the judge to decide what the punishment will be in this case. And if that happens, then the judge, the judge can apply the facts and, look at mitigating evidence, look at aggravating evidence, any type of punishment evidence, and the judge can assess your punishment anywhere within the punishment range of the offense. Okay, now, the next thing I need to talk to you about, the next right is, besides your right to have a jury trial or a bench trial, you have a right to have witnesses that come to court. Witnesses sit in that chair right there that have the microphone in front of it. We call that the witness stand. And what they will do, they can testify for you or against you. If you're representing yourself, or if you have a lawyer representing you, you can ask some questions if you represent yourself, or if you have a lawyer, your lawyer can ask some questions. We call that either direct examination or cross-examination. Now, you can waive or give up your right to have witnesses that come to court. What that simply means is that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses. Now, the other thing I need to talk to you about regarding testimony is your Fifth Amendment right against self-incrimination. What that means is this. Fifth Amendment of the United States Constitution gives us a right not to incriminate ourselves, not to testify in our case, right? So a lot of times we watch television and we see a television lawyer go up to the witness stand and ask the witness a question. The witness saying, I take the fifth. And what they're saying is, I'm exercising my Fifth Amendment right against self-incrimination. I don't have to say anything. I'm not saying anything. And if you think about it, it makes sense. Why does it make sense? Because the state of Texas has the burden of proof. And what that means is they have to prove that you're guilty beyond a reasonable doubt. You don't have to prove yourself guilty. Okay, that's their job. Okay, and so that's why you have a Fifth Amendment right against self-incrimination. Now, you can waive or give up the Fifth Amendment right against self-incrimination. If you waive or give it up, That simply means that you will be testifying. Now, the other right that you have is a right to have discovery. You know, the state has a file on you, okay? And in the file, they have all the evidence that they're gonna use against you in your case, right? You have a right to have access to that file. Your lawyer have a right to have access to that file. They have a right to see your statements, witness statements, police reports, lab reports. They have a right to listen to audio recordings, see video recordings, see photos, have a right to see documents or any instruments that they have, anything that they evidence that they'll be using in your case. You have a right to have access to that. All right. Now you can waive or give it up, which means that you will not be having access to it. Now, everyone that's here, yes,
If you have evidence, you can bring your evidence.
you can present a defense.
Okay.
That's what it's called. Yeah. You got the state present evidence and then you could
So if you
defend.
got video, you bring your video.
You can, yeah, I mean, in your defense.
Okay.
Okay, now, everyone that's here today, you've been charged with an offense, you've been arrested, you've been booked in a county jail, you've been, released on bond, you're either out on a cash bond, which means you paid the full amount of the bond to get out of jail, you're out on a surety bond, which means you paid a bondsman a percentage of the bond to get out of jail, or you're out of jail on what is called a PR bond, or a personal recognizance bond, which means that you did not have to pay any money to get out of jail. You was just released under your own personal recognizance. I said that to say this. Every day that you spent in jail can be used as credit towards your punishment. So for example, let's say you spent 5 days in jail. And let's say the state is offering that you serve 5 days in jail. So what that simply means is you don't have to serve any more time in jail. Why? Because you'll be given credit for the time that you've already served. Okay? Now, if they're offering 7 days in jail and you spend 5 days in jail, that means you will have to only spend 2 days in jail. Why? We subtract 5 from the 7 and leaves 2. Now, if the state is offering fine and court costs, now every day that you spent in jail, you are credited at $100 per day that can go toward your fine and court costs. So if you spent 5 days in jail, that's $500 that can go toward your fine and court costs. Now, if the state is offering you fine and court costs of $500, and you spent 5 days in jail, that simply means you won't have to pay anything. Why? Because the time that you spent in jail has already paid it off. Therefore, we say that you'll be given, it'll be taxed and retired. In essence, it's already paid. The time that your time in jail has already paid it off. Now, if they're offering fine and court costs of $700, you spent 5 days in jail, that means, which is $500, that means you would only have to pay $200. You'll be required to pay the $200 on the day that the case is disposed of. If you cannot pay it, no problem, because we could put you on what is called a payment plan where you can pay it off in small monthly installments. Now, if you cannot pay it off on a payment plan, no problem. Because we can convert the fine and court costs to what is called community service. That is, you perform community service at a nonprofit organization in the community, and every 1 hour of community service that you perform, you will be credited at $12.50. So in our scenario, if you owe $200, if you work 1 8-hour day, that's $100. So you work 2 8-hour days, that's $200, and you will pay off the balance of your fine and court costs. Okay. Now, Jefferson County has a program for first-time offenders. If you haven't had any trouble with the law before, first time, you got one or more cases, first time. They have a program. When I say Jefferson County, I'm talking about the district attorney's office. They have a program where they will dismiss your case, and you can get it wiped off your record. We call it expunged from your record. The program is called pretrial diversion. In order to participate in the pretrial diversion program, It has to be your first time getting in trouble with the law. And you have to have an attorney to help you with the application process. The attorney don't have to be hired, the attorney could be appointed. Okay? And it can't be an offense for unlawful carrying weapon or resisting arrest. As I mentioned to you earlier, if you get into the program and complete the program, they'll dismiss the case and you can get it expunged or wiped off from your record. It's called pretrial diversion. If you're interested, just let us know and we can put you in contact with the people that you need to talk to about the program. All right. Now, if you're a veteran of any one of the branches of the United States military, the district attorney's office has another program that is called Veterans Court. But Veterans Court is for veterans only. They will, once you get into the program and complete the program, your case will be dismissed and you can get it expunged like I mentioned earlier. But you have to be a veteran of any one of the branches of the United States military, then that's the only criteria. Okay. Now, this court, County Court at Law number 2 of Jefferson County, Texas, has a primary guard that started in the first 100 days of taking office in March of 2017. The program is called the CSI program. CSI is an acronym, CSI, that stands for Community Safety Initiative. It is a program that is designed to address the issue of what we call recidivism. I'll explain to you what recidivism is. Recidivism is when people commit crimes over and over again. They commit one crime and continue to commit another crime and they continue to commit crime. That's recidivism. Now, the program is designed through various partnerships that we have with agencies in our community. One of the agencies that we have a partnership with is the Spindletop Center. And we have some folks that's sitting in the jury box there from the Spindletop Center. They will come to you in a few minutes and tell you a little bit more about the program. But basically, the program that Spindletop has to offer today, they can do a private interview, either in the jury room at their facility, by telephone, or by text, whichever is convenient for you. Then they can do an assessment to determine what the mental health issue is. So, and then they can develop a treatment plan. And the treatment plan can be either outpatient or inpatient treatment to address the mental health issue. Now, you do not have to be incompetent or insane to participate in the program. You can merely suffer from anxiety or depression or any other host of mental illnesses, and they have the expertise to not only assess your mental health issue, but to address it as well. Now, if you have issues with drugs or alcohol, well, Spindletop has a program that's called ATAR. ATAR is an acronym that stands for Addiction, Treatment, and Recovery. We also have a partnership with our local drug and alcohol council that has a program that is called ATAR. ATAR is an acronym that stands for Addiction, Treatment, Assessment, and Recovery. Well, I mean, though they have OZAR. OZAR is Outreach, Screening, Assessment, and Recovery. Now, both of those programs are drug and alcohol recovery programs. And basically, what they would do a screening, private screening. Then they could do an assessment to determine what your alcohol and drug issues are. And then they could develop a treatment plan for either outpatient or inpatient treatment. Now, if you are unemployed and do not have a job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you're trained in any one of those areas, they will help you to get a job in the area that you trained in. Now, if you have not graduated from high school, if you do not have a GED, well, Spinnertop has a GED program, and Lamar CICE program has a GED program where you can get your graduate equivalency diplomas. Now, all of these programs that I just mentioned to you are free. It does not cost you anything but time. And like I said, in this court, we don't just give time. We take out time. That simply means we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I say that when you come to county court at law number 2 in Jefferson County, Texas, we do not just have court as usual, we have unusual court. It's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs that I just mentioned to you, just let us know and we can help you to get on the road to living your best life. So at this time, we'll have Tanya and Deputy Butler, our mental health Deputy Butler. They're gonna come here and tell you a little bit more about the program that Spinnertop has to offer.
Thank you, Jim. Good morning, everybody. I'm Deputy Butler of Jefferson County Sheriff's Department. I also help with the Spinnertop program. This is my partner, Ms. Tanya. She's a mental health professional. She's the one you'll be talking with if you become a Spinnertop client. If you do become a Spinnertop client and you need a ride to your doctor's appointment, or you need to go pick up a medical prescription, we're here to assist you in that. Okay. So the form that you have, fill it out if you want to. It's up to you. It's voluntary. It has no bearing on your case. It's just another source of help for you offering. Ms. Latanya should tell you more about the small top program and what they do.
Good morning, you guys. The form that Deputy Butler is speaking of is the little half sheet form, just in case you guys didn't know. As Judge Holmes stated, we do have programs for mental health, we have programs for substance use, we also have programs for IDD, which is the intellectual disorder. With those, I can speak with you guys about different things that go on with those symptoms or different things that you guys want to address. I know on the little form, there's also information about veteran. We do have someone on site that works with veterans. If you decide to go ahead and speak with us, I can make you an appointment on site right now. Or if you want to speak with, I can just go ahead and give you a little bit of detail of whatever it is you guys are needing. Question?
Well, like, right now, the doctor put me on disability for 6 months because I look, they preliminary show 3 types of cancers and diabetes and other stuff. Can y'all help me with like, because I'm not working, I can't work. So I need resources.
Yes,
Yeah.
let me give some resources. And if not, if you don't want to face to face right now, text, call, email, all available. Okay. Once you guys come through, Judge Holmes, I have you guys go ahead and turn in your paperwork. And once you turn in, if you didn't fill out the form, they can put it to the side. Okay. Thank you, guys.
Okay, thank you, Deputy Butler and Tanya. Okay, ladies and gentlemen, we're gonna give you time to fill out your paperwork. And once you finish filling out the paperwork, we're gonna put you into one of 3 categories. One category is you wanna hire an attorney. Now, if you wanna hire an attorney, your case will be reset today to give you time to hire an attorney. The other category is you would like to apply for a court appointed attorney. Now, if you qualify for a court-appointed attorney, your court-appointed attorney will be appointed today. And the last category is, you would like to waive your right to an attorney to represent yourself. Now, if you waive your right to an attorney to represent yourself, if you able to work out a plea bargaining agreement with the case, your case will be taken care of today. Now, if you need help with the paperwork that you have, we have our court staff here. We'll be happy to help you. And when I say our staff, that's including myself. We'll help you with filling out the paperwork properly. Now, it's gonna take us a little time to we're gonna give you a little time to fill out the paperwork. And it's gonna take us time to pick it back up and evaluate it and call you back up one at a time to the bench. Now, if you need to use the restroom, there are two restrooms right outside in the hallway. We had the men's restroom in front of the County Court at Law number 3, which is next door. And on the opposite side of the hall, in front of the 172nd District Court, is the women's restroom. You'll be allowed to go out into the hall to use the restroom, but please come back in. Do not leave the courthouse. If you leave the courthouse, and if your name is called, you don't answer, then your bonds are going to be, your bond is going to be forfeit. That simply means that a warrant will be issued for your arrest. You'll be arrested and placed back in the jail. And guess what? We'll have to go through this all over again. Okay? So this is gonna take us, it shouldn't take us that long to pick up the paperwork and go through it and have you to come up. And those who would like to talk to the prosecutors, you'll be talking to the prosecutors at the same time. Anybody have any questions? Yes.
On there where it says like, you plead no contest.
Mhm.
But I mean,
You're not fighting the charge.
you're not fighting the charge, you just want to resolve it.
Right.
You check the box on the bottom,
No.
Oh, you don't do that?
That's gonna be on some other paperwork
okay,
later on. That'll be on. Only thing you're checking on that is that you would like to either hire an attorney, get a court-appointed attorney,
No.
or you wanna waive your right to an attorney and represent yourself.
you just want to, you know,
Okay, yeah,
Okay.
so you gotta so you're waiving your right to an attorney. And you represent yourself, so that's the last box at the bottom to the left. Put your initials on that, sign the document and date it, and then you're gonna sign the form that is titled waiver of counsel for purpose of entering guilty plea proceeding trial, so 1 page document. That's the only 2 documents you have to sign. Yes,
Right, can I translate what you said to him in Spanish?
yeah, we have a translator
Okay.
that we can call in. Ms. Mo,
Yes, sir.
we'll get our translator.
Thank you.
Okay, anybody else? Anybody else? Okay, so we're gonna, now be mindful, we're still in court. And so conduct yourself accordingly. We're gonna get our, staff out here. We're gonna go through the paperwork, and then we should get you in and out as soon as possible, okay? So the court will be in recess. Yes, hold on.
The paper that says Jefferson County affidavit. Is
Right,
that for the,
that's if you'd like to apply for a court-appointed attorney only. You fill out the first page, and then on the second page, it says defendant's oath at the top. You fill that portion out, and then in the middle where it says unsworn declaration by defendant. Yeah, you fill out and then you stop. Okay, the other thing is this here. At the top of the document, it says state of Texas versus. Print your name on the line. Okay, versus it has a blank. Print your name. The reason why I'm saying print is because sometimes I can't read my own handwriting. So just print it, do your best job printing. Jefferson County Court, Law number 2 is back in session. The court is in session in cause number 26 CCCR 0208. This case is on the course of arraignment docket on today's date, March 31st of 2026. First case is Roberto Vega. And Mr. Vega, I need some bond conditions. Mr. Vega speaks Spanish. And we have Ms. Jennifer Raji, who is our translator. Mr. Raji, would you please raise your right hand? Do you swear affirm to interpret Spanish to English and English to Spanish to help you God?
Yes, sir.
Okay, you may put your hand down. How are you doing, Mr. Raji?
Good, Judge. Thanks for asking me, sir.
I'm doing fine. Thanks for asking as well. Ms. Haraji, ask Mr. Vega if his full name is Roberto Vega.
Yes, Judge.
And ask Mr. Vega to raise his right hand. Mr. Vega, do you swear affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, Judge.
You may put your hand down. ¿Cómo está? Bien, good. And Mr. Okay, Mr. Vega, I have before me 2 documents. First document is titled Judge's Explanation of Rights of Defendants Without Attorney. Do you is that the right one? Do you recognize this document?
Yes, Judge.
And is this your signature on the line that's titled defendant?
Yes, it's your Yes, Judge.
And are these your initials on the line that states you would like to have your case reset to hire your own attorney?
Si quieres tiempo para agarrar un abogado. Yes, Judge.
Okay. And so I think Mr. Vega speaks some English as well.
He's from Puerto Rico. So.
Okay.
Yes, sir.
And Mr. Vega, I also have before me a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
The presence of the opinion. Yes, Judge.
Okay. On page 2 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, Judge.
Mr. Vega, before you sign and initial these documents, did you read the document? Well, did Ms. Araji go over these documents with you in Spanish?
Sí, antes de firmar todo ese documento, sí te explicó.
And did you understand everything that Mr. Araji went over?
Sí, entendí todo. Yes, Judge.
And is everything in these documents true and correct to the best of your knowledge?
Y todo en ese documento es de verdad. Yes, Judge.
Okay. Okay, Mr. Vega, your case will be reset. And I need to give him some bond. You know what? I may have to sign these. You may have to go over them with him.
Yes, sir.
What I'll do, I'll check the ones that apply to him. Miss, might have to write the numbers on here. Now, Mr. Vega, we're gonna give you some bond conditions. And Ms. Roger is gonna go over these bond conditions with you in Spanish. First condition states that you cannot commit an offense against this state, any other state, or the United States. Do you understand the condition?
Ser otro ofensor en este estado, otro estado o en estado. Que sí, otro ofensor. Yes, Judge.
And the next condition states that the court can order that you be drug tested at any time. And if you refuse to be drug tested, the court can revoke your bond. Or if you test positive, the court can revoke your bond.
Y si usted no quiere, se lo puede quitar de mí. Y si lo haces y es positivo para droga, no se lo pueden quitar de mí también. Es sin
Okay.
límites.
Just let him know that he can't test positive for any drugs or alcohol.
Yes, sir.
You did, okay. And also, the third condition, he cannot communicate directly or indirectly with the alleged victim of the offense. And he cannot go near any residence, school, or other location frequented by the alleged victim.
Ok. Creo que yo estaba sin comunicar ni a estar en el mismo lugar o otro lugar con la víctima. ¿Entiendes eso?
Sí, el problema es que se lo he puesto de
Okay. He said, yes, sir.
And the next condition is he's prohibited from possessing a firearm or ammunition unless he is a peace officer that's engaged in employment as a sworn full-time paid employee of a state agency or political subdivision.
Okay. Just entiende.
Okay,
Yes.
he'll get a copy of these
Mhm.
bond conditions and his reset from our coordinator. Tell him to have a blessed day.
Que tengo y lo van a dar.
Thank you.
Okay, and thank you, Mr. Roger. Here you go. This is Mr. Vega. Yeah. White out. Okay, hold on. Hold on a minute. 2-6. 2-6. C. Oh. 8. 2-6. Oh. 8. There you go. It'll be a recess. Court will be in recess till 1 o'clock.